everyone. This is attorney Troy Tyson. I'm an attorney working in the Indianapolis area, and today I want to talk to you about civil matters and whether it's best to take a civil matter to trial or to settle it out of court. But first, a few things before I get started. This is for informational purposes only. This should not be construed as legal advice. This information does not establish an attorney-client relationship. And finally, most of the items that I'll be talking about are based on Indiana law. So if you live in a different state, you'll definitely want to check your local laws and statutes to make sure that they correspond with what I'm telling you. Now, a civil matter is basically anything that doesn't include a criminal context. So that might be small claims issues, that could be landlord-tenant issues, business litigation, maybe even some family law could fall under civil matters. Basically anything that doesn't involve a potential criminal prosecution would be considered civil law. So if you're a plaintiff or defendant in a civil matter, at some point you're going to be faced with a decision of, do you settle the case out of court or do you take it all the way to trial? Now, in some small number of instances, you will be faced with an opponent who's determined to go to trial at all costs and will not consider settlement. And if that's the case, you ought to live with that. But in most situations, settlement is always on the table, even if it isn't explicitly stated. So whether you're a plaintiff or a defendant, you will very often have to face that decision. And hopefully this video will help you to assess your particular situation and come to a determination of which of those options is best for you. The way to start here is to break down the different components of the case and do what I call doing the math. You basically want to break these down and do a cost-benefit analysis of going to settlement versus going to trial. And so the way you do that is you look at the total framework of your case, and you begin to ask yourself questions such as, what do you stand to gain in terms of money, in terms of peace of mind, in terms of time, in terms of getting your life back? And then you look at what you stand to lose in terms, again, of money, in terms of property, in terms of prestige and reputation, both of which can be severely affected by a civil trial or a civil matter. And you begin to assess these things. And let me say something about emotion, because emotion is often a significant factor and a driver in many civil matters. And emotion has its place, and the law acknowledges that emotion has its place, particularly when you're dealing with personal ties or family ties, or if you're dealing with family law. Emotion certainly has its place. However, it should play a very limited role in this analysis, and for a lot of reasons. But the primary reason is that very often the choice that you make, particularly if you choose to settle, is not a very emotionally satisfying one. Very rarely do you get to go to the trial and get the home run against your opponent that you're looking for. The law is often it's more subtle than that. It's more nuanced than that, and you really don't get those home runs or those knockouts the way that you would want to. That would be very emotionally gratifying to you. So very often the best option for you, the one that will save you time, the one that will be the most efficient, is not a very emotionally satisfying one. So emotion has its place, but it should be kind of put off to the side, and you want to look at this as logically and rationally as possible and kind of strip the emotion away from it in making this decision. Now let's talk about settling. Settling is an unfortunate term. It has negative connotations in our society, and usually it means either losing or giving up something and not getting the best out of your situation. I think that's unfortunate. I think a better term or terms that could be used would be negotiating or compromise. Settlement is a perfectly legitimate tool in the modern legal framework. The vast majority of cases in the civil arena settle out of court. Very rarely do cases go all the way to trial. So settlement is completely viable, and it's the way of the world in most civil matters. But that doesn't mean you want to just settle your case immediately. You need to do the analysis to make sure that it's the best choice for you. So some of the things that you'll want to consider are, remember that you're giving up something. Okay, that's the nature of settlement. By not going to trial, by avoiding the risks and the costs associated with trial, you're naturally giving up something if you want to settle. And I think a good way to look at this is to assume that you're going to get about 65% of what you would get if you did go all the way to trial. Of course, there's a huge amount of variance in what you could actually get or what your particular case entails. But just on average, let's just say you're taking 65% to avoid the time, the money, and the risk of going all the way to trial. View it from that standpoint. If you were to get 65%, would you be okay with that? And giving up everything else that comes with trial. Begin from that standpoint. Some questions you want to ask yourself if you're considering a settlement. Number one, how strong is your case? To me, this is the most important question because it will tell you how much leverage you have with the other side. It will tell you how good your chances are at trial, even though no one can guarantee, even the most experienced attorney can't guarantee a trial outcome. You usually have a sense of your chances at trial based on how strong your case is. And you'll know if you have a strong case because the other side will be much more willing to compromise, and the offers that they give you will be much stronger than in other cases. So you definitely want to start with that question, and if you're working with an attorney, hopefully you are, they will help you to assess just how strong your case is. But that, to me, is question number one. Number two is, could you live with the settlement award? If you didn't go to trial, if you were going to give up all the things that came with that, all the risks and the costs associated with that, could you live with what the other side is offering? And if you couldn't, could you negotiate them upwards to a point where you would be satisfied? And finally, you want to ask yourself, would settling save you a significant amount of time and trouble? Because if it's not, if it's going to be just as much trouble or almost as much trouble to negotiate with the other side and it's going to be acrimonious, maybe you want to consider going to trial anyway because you don't have much to lose in terms of it's going to cost you just as much in attorney's fees. It's going to be just as hostile and uncomfortable, and it's going to drag on just as long. So if it's not going to save you a lot in those areas, and you may not get a settlement award anyway, then maybe it's worth going to trial. So those are some of the major questions that you want to ask. In terms of trial, you want to begin with the same question again. How strong is your case? That should be the first question. Because sometimes, even though a settlement offer is very good, trial may still be your best option. And as I said before, if your case is very strong, chances are you are going to get a good settlement offer. So if you get this very attractive settlement offer, it's very important that you ask yourself, how strong is my case? Because if by accepting this settlement offer, I'm leaving something on the table by not going to trial, maybe that's not in my best interest. Again, your attorney, if you have one, could definitely help you sort this out and do this balancing act. The second thing you want to ask in the trial context is, what are your motivations for going to trial? And this is really important because if your motivation is strictly monetary or legal, then settlement should always be on the table. Okay? And what I mean by monetary or legal is you're a landlord who has a tenant who's just, you don't have any personal affiliation with the person. They're just 6 months behind on their rent, and you just want the money. You just want them to be paid. You want to be paid back. You want your damages, and you want to be done with it. That's a strictly monetary motivation and a strictly legal motivation. You just want justice before the court. You just want what's right to be done in your situation. There's not much more than that. And in that case, settlement, I think, should always be on the table. Okay? But there's another motivation very often in these cases, and that's based on the sense of justice. Someone was severely wronged, and they just want justice. And you see this, for instance, if you lost a child in a drunk driving accident, or you had a special needs child who was mistreated in a special needs facility or something along those lines that cuts close to home, that you feel like, or if there's a civil rights issue where your civil rights were violated. These very often, there may be monetary considerations, but very often in many of these cases, the primary driver for the people involved in these situations is a sense of justice. They want justice. And in those cases where money is really not the issue, trial is going to be a much more attractive option to you in those cases. And you shouldn't be swayed away from trial. Even if the other side does offer you something, if you're really pursuing justice, you should really push forward with that if that's the only satisfactory outcome, because settling in that case may leave you feeling less than satisfied because money was never the issue to begin with for you. I'd say that's a small minority of cases. Most cases are going to be monetary in nature and people who just want to set things straight and get on with their lives. So settlement in most cases should always be on the table. The final thing that you want to look at in terms of the trial context is you want to weigh the true costs of going to trial. When you're comparing trial versus settlement, very often people who are anxious or who are at least willing to go to trial don't really factor in all the things that are involved in going to trial. Of course, there's going to be attorney's fees. If in most cases, if you have a civil trial of any significance, there's going to be attorney's fees. There's going to be filing fees, court fees, which could be significant. If your case is of any significant volume or level of complexity, there are going to be expert witnesses, there are going to be standard witnesses, there are going to be depositions, interrogatories. There's lots to think about here. Also, there's going to be lots of time. It's not just the attorney who puts in a lot of work. I've seen this in a lot of cases where clients come in, they have a fairly complex case, and they want to hand it to the attorney and let him or her do all the work. And certainly some of that is justified. That's what you're paying them for. But a lot of times in order for an attorney to do a very good job for you, you have to be intimately involved in that process. So in many cases, it's going to take a lot of your time. So those are things to consider. Also, the stress and the pressure and the invasive nature of trial. Trials can be very invasive, and people can very often feel that their privacy is being violated, that their past is being dragged up before them, and it can be very uncomfortable. So those are things that you need to think about when you're considering going all the way to trial. So in conclusion, just to think about what you want to do and do you want to settle, do you want to go to trial? Some of the things that you need to consider are, what are the possible monetary rewards? Are you going into this based on justice, or are you going into it to try and seek a monetary reward for what you've suffered? Or do you want to just be free of a lawsuit? If you're a defendant, maybe that's your primary motivation. So think about what your motivation is. Secondly, be realistic and assess the costs, not just the financial expenses, although those are those should be considered, but also the time and energy, the stress, the pressure, the loss of your privacy, and also the risk of loss if you go all the way to trial. The next thing is do the math. Balance all of those pros and cons of each scenario and determine what you could live with. And finally, I would say to you, whether you go to trial or not, and if you have an attorney, they will probably advise you the same way, but always prepare fully as if you're going to trial, regardless of if you intend to settle or whether you actually intend to go to trial. Always prepare fully as if you're going to trial. It will prepare you for the worst case scenario. It will give you much more information, knowledge, and leverage in settlement negotiations, and it would just put you in a much better position all around if you assume that you're going to trial and prepare for that. So hopefully that helps you determine whether you should settle your civil matter or take it to trial. If you have any legal questions or if you need any assistance, please feel free to contact the Tyson Law Firm PC at 317-514-2681 or info@TysonLawFirmPC.com. Thank you.